Hey CompGovers, so this is going to be our third video for government. And this is going to be our final video for government. So just remember that for the AP CompGov exam, it's going to be based on three topics. It's going to be based on government, on society, and on sovereignty. So I'm going to finish up our government video with the judiciary. So this is topic 2.8, 2.9 of the curriculum for AP Comparative Government. And this is going to be all about the judiciaries. And again, I'm going to do the same thing, go over some major vocabulary that you should be aware of, and then I'm going to go over the case studies for our 6 different countries. All right, so judiciaries, um, it depends on the country, have different functions, and they all have different methods to appoint judges, to interpret the law, to apply the law, and to resolve disputes. So we're going to take a look at the various functions of the judiciary in our 6 different countries. What is probably the most critical topic of any judiciary is whether it's an independent judiciary, meaning is it a separate branch of government that isn't dependent on any of the other branches? Can it exist independently? Or is it being controlled by an autocrat? Or is it being controlled by a dictator? So, judiciaries are really important because they do tend to, and this is their function, is to protect, at least ideologically, protect the rights of citizens, of constituents. So, the degree of the judiciary's dependency from the other branches of government depends on the amount of authority the courts have to overrule executive and legislative actions. In some countries, it does. In some countries, it doesn't. So let's look at some of um, uh, the various types of degrees of authority that judiciaries have. So you can have a large degree of authority if the process by which judicial officials acquire their jobs. So if you get your job because you're highly qualified, you have a legal degree, you have experience, then there's probably going to be a lot of independence in that judiciary. But if you were given this job because of patronage, um, or because you are a yes man, well then maybe it's not so independent. The length of judicial terms. Now, this is a controversial thing. Term limits can be good, can be bad, but different countries have different interpretations of term limits. Like some have term limits, some do not. The professional and academic backgrounds that judicial officials are expected to have. So, are you highly qualified? Are you subject to an exam? Do you have to have certification, like a law degree? So that professionalism is another important part of that judiciary independence. And the process to remove judges from their posts. I mean, if it's is it an impeachment process, or is it just the executive gets to choose to remove you? So this is another critical part of judiciary independence. Now, in judiciaries, especially independent ones, can strengthen democracies by being truly independent in a sense that it checks and balances the other branches of government. So if one branch does something that's a little outrageous, can the judiciary step in and say no, 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 no? We're going to see examples of that in our countries, protecting the rights and the liberties of the constituents, and we're going to be looking at some definitions of that. Another definition we're going to be looking at is rule of law. So, is everyone subject to, no matter who you are, no matter what office you hold, are you subject to the law? And of course, maintaining separation of powers, that independence. So let's kind of drill down on these terms a little bit more. So, like rule of law as opposed to rule by law. So, rule of law is ideologically what the United States has. So, it is emphasizing the primacy of the legal code over the actions of prominent officials. So, even the president, even the senators, even policemen, even governors, they are subject to the same law as the constituents. Or is it ruled by law, where law is seen as a tool used by officials to control the population? They rule by law. All right, so there is a difference. In some countries, in our 6 countries, are rule of law, some are rule by law. Political rights. Political rights are the things, same thing with civil liberties and civil rights, are the things that judiciaries are supposed to protect. So, or at least if you have a grievance because you feel like your political, civil liberties or civil rights have been violated, that you have something to turn to in order to receive justice, right, in the judiciary. So, political rights are the rights to have a voice in government. Can you freely vote? And can you referendums and recalls? Do you have that ability? Do you have a political voice? Civil liberties. Civil liberties are a little different from civil rights. Civil liberties are protections against government action. So these are protections against government actions. For example, First Amendment of the Bill of Rights guarantees citizens the right to practice whatever religion they please. Government then cannot interfere in the individual's freedom of worship. So realize it's protections against government actions. Civil rights, in contrast, refers to positive actions of government, um, the things that government can take to create equality or at least equal conditions for all Americans. So it's usually associated with protections of minority rights, such as do African Americans have the right, should have the right to vote? Women should be able to be paid equally as opposed to men. So these are positive actions that the government takes as opposed to protections against the government. All right, common law. Common law is based on tradition. It's not necessarily 100% written down. That's more code law. But common law is based on tradition. It's based on precedent. It's based on past practices. Um, some things are written down and some things aren't in common law. In code law, it's absolutely written down. It's based on a comprehensive system of written rules, written codes of law, and are usually divided up, these codes, into commercial, civil, and criminal code. All right, so those are our definitions. Make sure we understand them. Now let's go to our case studies. So, the judiciary in the UK. So, the United Kingdom is considered to use common law. This is what makes the UK kind of different than some of the other ones. Um, but it does enforce rule of law, right? So, everyone is subject to the law, even the Prime Minister. And the judiciary in the UK is considered to be independent. Probably one of our only countries that is absolutely considered to be independent is the UK. So these are the redeem. You'll notice that I start all of these case studies with kind of their most common characteristics. So we already discussed what common law is based on precedent and interpretation. Rule of law, we've already explained that. It emphasizes the primacy of legal code over, or legal law over action of prominent officials. They were one of the first, the UK, the English, were one of the first to establish trial by jury. Um, Now, the judiciary is a little more limited than the US because they don't have judicial review. Instead, they have parliamentary sovereignty. This the role is really to determine whether government violates common practice or previous acts of parliament. Um, that's parliamentary sovereignty. So the judiciary in the UK, I will tell you, does have um, does have it does have judicial review, but um, it doesn't have to be obeyed by the other branches. So essentially, it does not have judicial review, rather parliamentary sovereignty. All right, so the judicial system does not exist in any kind of unified fashion. The only like national judicial system that exists is the relatively new Supreme Court that was established in 2009. Most of the judicial system is decentralized into courts in England, Scotland, Wales, Northern Ireland, each with their own separate legal authority. So it's heavily decentralized with the exception of the Supreme Court. So the Supreme Court was established in 2009, and it is about 12 law lords from the House of Lords And like I said, they have non-binding judicial review. That's what I was trying to explain before. That it does have it, but it doesn't. It's non-binding. No one has to listen to it. So essentially, it does not. It's Parliament that really has the sovereignty there. There is Supreme Court does serve as a court of appeals. It is a final court of appeals. A lot of the things that the Supreme Court hears is protection of human rights, protections of civil rights, and civil liberties. And it does also rule on cases of devolution. So if there's any kind of problems between some things that are happening between England and Scotland, right, these devolved judiciary systems, then the Supreme Court will hear those cases. Okay, so just an example of the independence of the judiciary. In 2019, Boris Johnson, you all might remember this, suspended Parliament, even got the Queen to give him blessing to do this. And the reason he suspended Parliament was to get his Brexit plan passed. So he suspends Parliament. And everybody's like, wait, I don't know, can you do this? Well, it went to the Supreme Court, and the Supreme Court did rule Boris Johnson was unconstitutional. So the Parliament was not disbanded. So again, you can see the independence of the judiciary because it checked, right? It checked the power of the prime minister or the executive. All right, let's move to Russia. So Russia's government uses the judicial system to target opposition. That's really what characterizes it. And although the Constitutional Court does have technically the power of judicial review, this power has not been used to limit the authority of the other governing branches. It has not been used maybe to even to check Putin. So even though it exists, it doesn't really. Um, okay, so the Constitution of 1993 does outline a structure of a judicial. Um, and I will say that in general, it's supposed to have an independent judiciary, much like it's supposed to have judicial review, but it doesn't. Um, it's generally assumed that the judges can be bribed. I'll give you some examples of its independence. I'm sorry, its lack of independence. In 2005, there was a dispute between Putin and the court, and it prompted Putin to relocate the Constitutional Court from Moscow, where it traditionally sat, to St. Petersburg. So it was kind of banished to the hinterland. And it was proposed in 2005, and it was completed in 2008. Another example of its lack of independence is in 2020, the Constitutional Court approved, and y'all remember this, Putin's constitutional amendments to extend his terms in office. Well, of course, everybody's like, oh, is this constitutional? And it went through, quote unquote, a democratic process by going through the Constitutional Court, and the Constitutional Court just rubber stamped it, right? So, again, not very independent. It's not checking the power of Putin, the executive, in either of these examples. Okay, so the Constitutional Court has 19 judges, technically with judicial review, but not really. It also has a Supreme Court, and this is different from the Constitutional Court because the Constitutional Court is supposed to have judicial review, but doesn't. Supreme Court is the highest appellate court in civil and criminal cases. Below the Supreme Court are the district courts, and it it's the primary criminal trial court. Um, Generally, if you're accused of a serious crime, you technically have the option for a jury trial. So, like the UK, jury trial, yay, consisting of 12 jurors. But I will tell you, in practice, the number of jury trials remains small. Out of about 600 cases per year, about go to jury trial out of about 1 million cases per year. They also have regional courts. And this is another problem. Judges are nominated by Putin, the president, and confirmed by the Federation Council, which, as we learned yesterday, is also a rubber stamp legislative body. All right, moving on. China. China has rule by law, not rule of law, right? And real power is with the Chinese Communist Party. So the judicial system is subservient to the decisions of the Chinese Communist Party. And the CCP controls most judicial appointments. So remember at the beginning we were talking about independence of judiciaries and how judges get their jobs. Well, they get their jobs here through the Chinese Communist Party. So it is considered to be a weak body, the judiciary, and no real independence, no judicial review. And it is a four-tiered. The People's Court is four-tiered. It has a Supreme Court. It's very weak, but it is there. And what the Chinese are trying to do is establish at least a reputation for independence, because, as we all know, a lot of Western companies do business in China. And Western companies are often cautious or reluctant to operate within China because of the weak judicial system. Remember, judicial systems are supposed to protect constituents, including businesses. And so, if there is a weak judiciary, then Western businesses are reluctant to do business in China. So, there's been an attempt to try and make the Supreme Court a little more independent to attract Western investment, but it still remains weak. There are provincial courts. These are right under the Supreme Court in the various provinces. There's civil and criminal courts. Civil courts basically is civil, loss of property, consumer fraud against businesses, consumer fraud against local officials, consumer fraud against government agencies. But again, it is it is run by the CCP. Criminal courts, it's got a 98 to 99% conviction rate as of 2004, and it does lead the world in executions. So don't get arrested in China. All right, Mexico. So Mexico is in transition. That's what you need to remember about Mexico. It's in transition. It's attempting to try and create a more independent and more effective judiciary. So the Supreme Court does have the power of judicial review. Constitutional amendments have been implemented with the intent to make the system more independent. So let me give you some examples. President Zedillo, he was in office between in the late 90s. He attempted to strengthen the court by emphasizing rule of law and refusing to interfere with court judgments. So, again, that independence. President Fox, who came after Zedillo, continued these policies. So now we have another 6 years, now 12 years, now another 6 years with Felipe Calderon. He also attacked judicial corruption, so trying to make the judicial system more independent, more effective. 1995, there were reform laws that made it so that judges now had to take exams in order to prove that they were qualified to be a judge. So that kind of started to stem some of the historic problems of patronage, right, under the PRI. In 2008, this reform required public trials by 2016. Public trials, because if they're all behind closed doors, then who's checking, right, to make sure that these are upholding the rule of law. So the legal system, much like the United States, is code law as opposed to the UK. The Supreme Court has 11 judges, are called magistrates. It is the highest court, nominated by the president, approved by the Senate, kind of like in the United States. They do have a 15-year term, unlike the United States, that's a life appointment. But historically, the appointments have been through patronage. But again, there's been attempts, remember, it's in transition, attempts to make it more competitive with the 1995 merit system reforms. Mexicans, despite all these reforms, still are entrusting the court system because of its history of patronage, but also now the drug cartels. Drug cartels are now bribing judges and all of this. So it's still struggling. It's in transition. It does have judicial review, but it's limited because in order for a law to be looked at by the Supreme Court to determine whether it's constitutional, Congress has to, so cases are reviewed if 1/3 of Congress asks the court to review it. So only 1/3 needs to ask the Congress to do it, and then they will do it. So it's not just up to them 100%, where in the United States it is up to the Supreme Court whether they are going to hear a case or not. Let's see. Judges are not a prestigious position, so there's a high turnover rate within Mexico. Nigeria. So the Nigerian judiciary has the power of judicial review, and an effort has been made to reestablish its legitimacy and independence by reducing corruption. Has it done it? No. But, much like Mexico, it's kind of in transition. I don't even know if it reaches a level of transition. It's struggling to reestablish legitimacy and independence, but is not necessarily doing it. So it's not even reached the level, perhaps, of transition like Mexico. All right, so they have a little interesting situation in Nigeria. Half the country is Muslim. So they have a federal system. Because they have a federal system, they have Sharia Islamic courts, particularly up in the north. 12 northern states have, in addition to a secular court, a Sharia court. This is often referred to as the dual federal state court system. All right, highly corrupt. Yeah, just a lot of corruption that exists here. There are 15 judges in the Supreme Court. It is the highest court, the highest appellate court in Nigeria. Judges are recommended by a judicial council appointed by the president, confirmed by the Senate, just like we see in Mexico, just like we see basically in the United States. Um, has judicial review constitutionally, but it's not exercised. Um, they do also, in addition to the Supreme Court, which is the highest court that does have judicial review, there is also a federal court of appeals, as well as regional courts below the Supreme Court. And the problem with these other courts, the federal and regional courts, is that they lack training, they lack clout, they lack legitimacy. Are these people knowledgeable of the law? Probably not. There's no qualifications like there is in Mexico. Many northern states have adopted Sharia law with Sharia courts for cases involving Muslims only. Non Muslims can establish in the South their own traditional or customary courts based on their local traditions. If they choose to do it, it's up to that state. Secular courts do, although, retain ultimate or supreme jurisdiction. Their legal system is mixed. It's largely based on English common law, which is complicated by all the various different Sharia and traditional law in addition to secular law. So it is based on common law, like the UK. So think Nigeria, a former colony of the UK, also has common law, but a presidential system, even though they tried a parliamentary system at the beginning. Last but not least is Iran. So Iran's major judiciary's major function is to ensure that the legal system is based on religious law. So whereas Nigeria is like half of religious law, Iran is all religious law. So all judges must be trained in Sharia law. So they have what's known as a chief judge. This is like a high-ranking position. It's the head of the judiciary, appointed by the supreme leader. Um, the chief judge also can nominate half of the guardian council. That's 6 members of the 12-member council, with the Majlis' approval. The chief judge needs an understanding of Sharia law. He is a cleric, right? So this is a religious person who is head of the judiciary, but largely doesn't get involved in judge duties, but rather is just a manager and oversees courts. There are two types of law that exist. So it's not code law or common law, it's Sharia law. Um, so it's Islamic, it's basically Sharia law. And then Ganun. Ganun is secular law. So it's non sacred legislative law. It covers business contracts, labor standards, the environment, that kind of stuff. So Ganun and Sharia. There is no judicial review because of jurist guardianship. The idea that the supreme leader and religious law is takes precedent over anything else. Nothing can overturn that. So there's no judicial review. So the jurist guardianship, the guardian council, supreme leader, the assembly of religious experts have final say on any interpretation of law. And the interesting thing about Iran in terms of their court system, they have an inquisitorial system as opposed to an adversarial system. No government prosecutor versus a defense attorney. That doesn't exist in Iran, and it's what we just kind of assume to be the case everywhere because that's what we have: the prosecutor versus the defense. Rather, a judge takes sole responsibility to find facts of cases by talking to defendants and prosecutors. So there is no trial by jury here. It's all based on a judge. It's called an inquisitorial system. All right, guys, this is it. I will see you guys tomorrow.